Is the traditional court system the best way to resolve disputes? Or could there be a more efficient, less cumbersome solution? Enter arbitration, an alternative dispute resolution method that has gained traction over the years, especially in India. Stepping back in time, the Indian Council for Arbitration, or ICA, was established in 1965. This government initiative aimed to provide quicker, more affordable solutions through arbitration and conciliation, regardless of geographical boundaries. The effectiveness of the ICA has been recognized globally, with arbitration centers scattered across the world. Remarkably, it handles over 400 domestic and international arbitration cases annually in the Asia-Pacific region alone. The Mumbai Centre for International Arbitration and the Nani Palkiwala Arbitration Centre stand as major arbitration institutions in India. Indian arbitration laws are governed by the Arbitration and Conciliation Act 1996. This act covers both domestic and international arbitration, outlining the establishment, composition and jurisdiction of the tribunal. It also provides procedures for making arbitral awards. The Act has been amended several times, most recently in 2019, following the 2015 amendment that set an upper limit of 1 year for arbitral proceedings. The Arbitration Tribunal has the power to grant various reliefs, including declarations, injunctions, payment of money, and other specific performances. Arbitration awards are divided into two categories: domestic and foreign. For domestic arbitration awards, there's a 90-day expiry period, which can be extended upon application. Parties also have the right to file an execution petition in civil court. For foreign arbitration awards, the procedure is similar, but there's no set limitation for enforcement. While arbitration has many advantages, such as saving time and money, allowing parties to settle, and choosing an arbitrator, it does come with its set of challenges. These include court interference, lack of provision for a specialist arbitration bar, and lack of transcription facilities in India. However, these issues are being addressed, and measures are being taken to improve them. To sum it up, India's arbitration system has been a resounding success. It provides a solution for resolving disputes without going to court, saving both time and money. With its significant international presence and continuous improvements, the Indian arbitration system is a force to be reckoned with. So why stick with the traditional court system when arbitration offers a more efficient, cost-effective and flexible solution? As we continue to evolve, it's essential to embrace solutions that not only meet our needs but also enhance our experiences. Arbitration, with its myriad benefits, is one such solution. And with that, we wrap up today's discussion. Remember, progress lies not in enhancing what is, but in advancing toward what will be. Subscribe to the channel for more enlightening content. Thank you.